Good evening, everyone. Today we are going to discuss the topic of nuances of bail. So I'll discuss various provisions under CrPC dealing with bail and what are the implications thereof and how exactly you will try to use them during your theoretical examinations or practical experiences, whatever it is. I'll try to uh, discuss all of that. And the class or this session I would put it should be really interactive if you would ask all your doubts. So please hold your doubts until the end of the session and then either type them or you can just speak and I'll try to clarify all of that. So without wasting time, we'll actually start with the presentation. Yes. So the topic today is the nuances of the provisions of bail under CRPC. As we all know, bail comes from the word bailier. That's a French word which means to deliver or hand over. It is nothing but judicial release from the custody or setting a person at liberty pending trial on security of his appearance. The whole principle of bail, I would say, is based on the doctrine that the personal liberty is to be given prime importance and without the trial or before the completion of the trial, an accused is always presumed innocent. And what is the purpose of custody? That is to secure his presence before the trial. And once we know that the purpose of custody is to secure his presence before the trial, and we know that there is Article 21 in the hit side, and the basic presumption of innocence principle is there. So then the purpose of bail becomes more important because if during custody the purpose of custody is to secure his presence before the trial and even without he being in custody his presence can be brought before the trial court, then in such cases there is no requirement for the accused to be in custody and then he should be uh, given the chance of being out of the custody till he is actually proven guilty. So that is the purpose of bail. Now we'll discuss all the provisions one by one. First provision is bail in cases of bailable offences. Bailable offences is defined in section 2A, that is an offence which is shown as bailable in schedule 1. So what does 436 say? That person arrested and detained without warrant or appears in court and he's ready to furnish bail, then he shall be released on bail. So there will be various provisions we'll discuss, and but before that, please know that there are certain kinds of bail. One is mandatory bail, that is shall provision where the CRPC actually mandates that the persons should be released on bail. Then there will be discretionary bail where CRPC would give the right to the court that he'll decide whether bail should be given. There will be other kinds of bail such as bails in appeal, revision and review, a reference. In all those cases also bails can be given and there can be a default bail under section 167(2) CRPC and 436A of CRPC. Now we are discussing one mandatory bail, that is bail in bailable offence. So it is saying that if it is a bailable offence and the person arrested and he is detained without warrant and he appears in court and he is ready to furnish bail, then he shall be released on bail. So it is a mandatory provision. There is no discretion. There is also a proviso which says that uh, if there is an indigent person, that is, if a person cannot furnish bail even after he has been offered bail within 7 days, then he shall be presumed to be an indigent person and he can be discharged without sureties because the court will presume him as such. Again, a bail has conditions regarding time and place of appearance, and if there is a failure to comply, then on subsequent occasion, even if it is a bailable offense, then it can be refused. So there might be a question coming up that in what cases, in what bailable offenses can can a bail be rejected in cases of bailable offenses? So this would be the answer. If bail has conditions regarding time and place of appearance, and the accused or the person who has been offered bail, fails to comply with the same, then on subsequent occasion it can be refused, and his bond can be forfeited. In DK Jindal versus State of Bihar, in this case, it was given that a bail application cannot be dismissed without assigning a reason. Of course, this order of bail is a appellable order, and person aggrieved, whether the government, I mean the PP concerned, or the accused himself, can approach the higher forum under section 439. So then coming to section 437, that is bail in cases of non-bailable offence. This is one kind of bail which is a discretionary bail and not a mandatory one. So in this cases, if person arrested and detained without warrant or appears in a court, which court other than High Court or Sessions Court, then it is saying that a person arrested is detained without warrant and it is a non-bailable case and he is brought before a magistrate court, then he may be released on bail. So it is a discretionary provision. Bail here is a discretion of the court. In all the non-bailable cases, the basic difference between bailable offences and non-bailable offences are that in bailable offences, it shall be a right of the accused. In non-bailable offences, there is no right of the accused. But it is not like in non-bailable offence, bail cannot be entertained. It will be entertained subject to the discretion of the court. And then discretion must be legal and reasonable. It cannot be arbitrary, or it cannot be without assigning any reason or legal cause. The exception to this rule is that in offences which are punishable with death or imprisonment for life, in that case, no bail shall be given by the magistrate. Or in a case where the accused is previously convicted in a cognizable offence which is punishable with death, imprisonment for life, or 7 years of imprisonment or more, in such cases also, bail can be denied. There is also another instance where bail can be denied, bail will be denied in fact, that is in two or more previous conviction has happened to the accused in cognizable and non-bailable offences. There is also another exception to this rule, that is, this is an exception to the exception, that is, bail can still be granted even if all the three things that we discussed, in which cases the magistrate shall not grant bail in a non-bailable offence, bail can still be granted if he is below 16 years, or she is a woman, sick or infirm person, or the magistrate is of the view that there is a just and reasonable reason for doing so. Another important provision is that a witness identification cannot be a reason for rejecting a bail. If offences alleged are punishable with death, life imprisonment, or 7 years or more imprisonment, then there is a mandatory provision that the PP or APP concerned shall be given a chance of hearing. Without hearing them, the magistrate cannot release the accused if the offences offences alleged are punishable with death, life imprisonment, or 7 years. Another provision which has been given is that during any stage, if reasonable grounds are there that he has not committed a non-bailable offence, then he can be released with discretion pending such investigation, inquiry, or trial. So basically, at any stage, if the magistrate is of the view that he has not committed a non-bailable offence, then he can be released with discretion. There is also another provision which says that if the offences alleged are punishable with imprisonment of 7 years or more, or offence, abatement, conspiracy, attempt to commit offences under chapter 6, 16, 17 of IPC, then conditions can be put which are necessary to ensure attendance of the accused to ensure that he does not commit similar offences or any other condition. All these conditions can be put if the offences alleged are the offences under these chapters or which are punishable with imprisonment of 7 years or more. The considerations which are to be taken into while granting a bail under this section are gravity of the offence, probability on the basis of the evidences whether the accused will be convicted, age of the accused, antecedent of the accused, committed under which circumstances, chance of threatening the witness or tampering the evidences, or any other considerations which are the interest of justice. All such considerations are to be looked at. And also, the reasons are to be recorded while enlarging only. So, whenever in a non-bailable offence there is a bail being offered to the accused, there should be reason assigned. Any person released on bail, and in such cases it can be cancelled and rearrested. That's not an issue, but then reasons has to be there. Another important provision, which I also will take it into the section of default bail that we'll discuss later, is that if trial is not completed within 60 days from the first day of hearing and he was in custody for the entire period, I mean that the accused is in custody for the entire period from the day of the trial, from the day of the first hearing, and the trial has not actually commenced within 60 days, then he shall be released on bail to the satisfaction of the magistrate. And if he is not released, then the reasons must be recorded. Completion of trial and before judgment, I mean, after completion of trial and before passing of judgment, if the court is of the view that the accused has not committed the offence, then he shall be released on bond without sureties. The purpose of this is that if the trial has actually been over and the magistrate or the court is of the view that the accused has not committed the offence, then there is no reason to keep him behind the bars. So then he should be released at once and he should be released on bond without sureties. Then comes 438, that is anticipatory bail or pre-arrest bail. This is another section of bail, that is bail in anticipation of arrest. In such cases, this is in fact a pre-arrest bail, though I would say, even though the bail order that is passed under this section is done pre-arrest, still it comes into picture once arrest is made. So the general principle that bail is always given after the arrest or after the accused has been arrested is confirmed here. So even in 438, many people have the view that this is actually a pre-arrest bail. So this will come into picture, this will come into the existence even before arrest has been made. No, it is not such. When it is being said that it's a pre-arrest bail, that only means that the bail order is a pre-arrest one. That is, the order has been passed before actually the arrest was made. But then it will come into picture only once arrest is effected, and then only he can be released on bail. So this is a slight deviation from the normal bail rule. So if a person is apprehending arrest for a non-bailable offence, another thing you have to make it clear that no anticipatory bail can be granted in cases of bailable offence. So a person who is apprehending arrest, and there must be a reasonable apprehension of being arrested in a non-bailable offence, then he can apply before the High Court or the Court of Sessions for a direction to be released on bail once he is arrested. So this is nothing but a direction of the higher court that once this anticipatory bail is issued, then once the accused is arrested, he shall be released on the conditions that have been laid down in the anticipatory bail. Points to be considered are nature and gravity of the offences alleged, precedents of the accused, that is, what are the criminal antecedents of the accused, possibility of him fleeing the jurisdiction, that is, whether he can actually leave the jurisdiction of the court. Another ingredient which is to be looked into is misuse of criminal machinery for arrest of someone. All of these are to be considered before granting an anticipatory bail to the accused. The provision of 7-day notice to the PP and SP is there before actually giving. This is a practice. This was This is being done. That the 7-day notice is given to the VP and SP. Applicant's presence can also be mandatory if necessary. But in Balchand Jain versus State of MP, it was said that he said anticipatory bail can be passed ex parte as well without notice. Conditions which can be put here are that he shall make him available for the interrogation when required, and he shall not make any inducement or threat or promise to dissuade a person from disclosing the facts. He shall not leave India without permission or such other condition as laid down under section 437. So all these conditions can be. If any person thereafter is arrested, then he shall be released on bail, and the court, after taking any cognizance, must insist on bailable warrant. There can be another question that whether in anticipatory bail a non-bailable warrant can be issued by a magistrate. Yes, the answer is yes. It can be issued, but the magistrate must at first instance insist on bailable warrant. Of course, if the bailable warrant does not turn up, and then later on it can be uh, I mean, the NBW can be sought help of, but the provision says that the purpose of or the purpose of granting anticipatory bail by the higher court, that must be given due importance, and the magistrate taking cognizance must insist on bailable warrant. In G Singh, that is Gurvak Singh versus S Singh case, there was an observation that a blanket order, that is never to arrest an order, such order cannot be passed. That is, an accused cannot say that an order may be passed by the court granting me an immunity that I will never be arrested in any case. It will only be case specific, and the accused has to make out the specific case, how he is apprehending an arrest in a non-bailable case. In each case, and on its merit, an anticipatory bail can be granted. In the case Savitri Agrawal versus State of Maharashtra, it was held that the belief or fear of arrest must be based on reasonable grounds. And when it says reasonable ground, that means there must be a reasonable fear that you cannot say that just because an FIR is lodged, there will be an arrest made, or because this has happened, uh, you have to completely justify how you are reasonably apprehending an arrest in a non-bailable case. You have to do that. In Ernest Kumar versus State of Bihar, it was the direction was given that a mandatory notice is to be served to the accused before to appear before the police under section 41A in the anticipatory bail applications under section 498A. Another important thing that comes into picture is that whether the anticipatory bail has any time limit. That is, does it last forever? I mean, can an anticipatory bail be granted and he will never be arrested, or that can be so it shall last till trial is complete or the bail is cancelled. If the bail is cancelled, of course, that will end. But if it is not cancelled, then it shall last till the trial is complete. In S. Singh versus State of Rajasthan, it was held that in dowry deaths and economic offences, there shall be no anticipatory bail. And of course, this anticipatory bail does not apply to SCST Act as well. That there are certain exceptions. Anticipatory bail cannot be granted. Another important case which you all must go through is Gurvak Singh Sibia versus State of Punjab. The Apex Court has laid down general conditions for granting an anticipatory bail. That is, the power under Section 438 is extraordinary, and it is to be exercised in special cases only. It does not grant protection on any of the offences that have yet not been committed or that no accusation has been made. So that means if the offence has not been committed, with an intention to provide the accused an immunity from arrest as a blanket order, no such relief can be sought for, or it cannot be granted by the court as well. Also, it says that the power under Section 438 is not unguided and it's subject to limitations mentioned under Section 430. So, actually, the 438, though it seems like it, it gives unfettered power to the High Court, it is actually fettered under Section 437, and the limitations that are mentioned there apply to Section 438. Also, it has been held that apart from what has been stated in 437, a special case is to be made out by the accused for the grant of anticipatory bail. So the accused has to satisfy in each case how he is entitled for an anticipatory bail, and each case are to be decided on its own merit. This section cannot apply when there is a possibility of collecting incriminating material from the accused and information regarding the evidence under Section 27 of Evidence Act and the remand of accused under Section 167(2) is essential for the collection of relevant states of evidence. So, if there is a possibility of collecting incriminating material from the accused and information regarding the evidence under Section 27 of Evidence Act and the remand of the accused under 167(2) is essential for the collection of relevant states of evidence, in such cases, this section cannot apply. All these are guidelines given in Guru Singh Sidhya. You must go through this judgment as a lawyer, as a student of law. This is a very important case which actually lays down the jurisprudence of anticipatory bail in full. In cases of offences punishable with death or imprisonment of life, bail under this section cannot be granted unless the court at the very stage is satisfied that such charge appears to be false or groundless. So it is also provided that in cases which are punishable with death or imprisonment of life, then under this section, bail cannot be granted. No anticipatory bail can be granted in cases of economic offences, that is, cheating cases, etc. Then no anticipatory bail should be granted. Another important case is that S. Satalingappa Maitre versus State of Maharashtra and others, in which it was held that Gurbakh Singh judgment must be followed and the anticipatory bail can be granted for an unlimited period until the trial is complete. Until the trial is complete, it will last. It will last until an unlimited period, and the decision, the guidelines given in Gurbakh Singh's Sidhya judgment, those were reiterated in Adri Dharandas with the state of West Bengal case. Uh, in this judgment, it was held that the anticipatory or bail order shall be for a limited period. Basically, whatever previously in Siddharam Satlingappa Maitre, it is saying that it will be for an unlimited period. But in Adri Dharan Das versus State of West Bengal, it is saying that it will be for a limited period, after which the accused is required to surrender and obtain a regular bail, which was passed without due regards to the act and law. Because obviously, the anticipatory bail is passed without actually looking into the entire case that has come to the court. So, in this case, the judges were of such humble view, but then, as it was a two-judge bench judgment, thus it cannot overrule Gurbakh Singh's judgment, which was a five-judge bench, and that's why the Gurbakh Singh judgment, which is saying that it will last for an unlimited period of time, it shall prevail. Sushila Agrawal versus the state of Delhi, it is also saying that there will be no time limit for the anticipatory bail, and the protection granted to a person under Section 438 CrPC should not consistently be limited to a fixed time. It should be in favor of the accused without any restriction. Another important provision is that though Section 438 confers concurrent jurisdiction both to the Sessions Court and the High Court, the Sessions Court should be moved first. In a recent Odisha High Court judgment also, the Honorable High Court of Odisha has reiterated this view, and the Sessions Court is the court which should be approached first, and then only the High Court's power must be invoked. And it is not like in all cases the accused will approach the High Court at the first instance. Even though there is a concurrent jurisdiction, that is, the power, the jurisdiction is vested both with the High Courts and Sessions Court concurrently. Now comes Section 439, which is saying about special power to High Court and Court of Sessions to grant and cancel bail. So these cases, this is providing actually wide discretion to the High Court and Sessions Court while granting and cancelling bail. So it is actually applicable to all the offences, and any person can be released who is accused of any offence, and the High Court or Sessions Court can release him on bail after imposing any condition. Also, the High Court or Sessions Court can modify or set aside any condition imposed previously by a magistrate while releasing a person. So it can either release any person accused of any offence, it can modify an order, it can set aside a condition imposed by a magistrate. So it is providing all the powers, unfettered powers, to deal with the bail. There is a specific mandatory provision that mandatory notice to PP or public prosecutor, unless reasons are specified, are to be given in offences which are exclusively triable by court of sessions or punishable with imprisonment for life. So, in cases which are triable with court of sessions exclusively or which are punishable with imprisonment for life or more, then in that cases, or imprisonment of life or death for that matter, in such cases, mandatory notice to be given to the public prosecutor. Now, after discussing all this, we must know that who can cancel bail. So, if High Court grants bail, then only High Court is the person. High Court is the competent authority who can cancel the bail. If Sessions Court grants bail, then the High Court and the Sessions Court can cancel the bail. If the magistrate grants bail, then the High Court, Sessions Court, or the magistrate himself can cancel the bail. So, if an authority has given the bail, then he himself or any person who is in a higher pedestal in the dispensation of justice system can cancel the bail. Now, there are other provisions of bail in CrPC, such as a bail enumerated in section 389, that is release of appellant on bail and suspension of sentence pending. So, an appellate court can order the suspension of sentence, and the accused can be released on bail or bond only while disposing any appeal by a convicted person. So, this is a may provision again. The appellate court can or may order for a suspension of offence, and we can release him on bail. But the offence, if is punishable with death, life, or 10 years of imprisonment, then a hearing opportunity has to be given to the people. Power under this section can be exercised by High Court as well. There is this provision which is talking about this. And another provision is there under this section is that convicting court convicting court shall release the accused on bail if applied by the applicant, and if he is already on bail and there is a sentence of imprisonment not exceeding 3 years, or it is a bailable offence. So the appellate court can release or may release if the person is applying for a bail, and if the such offence is punishable with death, life, or 10 years of imprisonment or more, then hearing opportunity will be given to the PP. And the convicting court, the court which is convicting, we're not talking about the appellate court here, we're talking about the court who is actually convicting. It shall release the person on bail if the imprisonment that has been awarded is not exceeding 3 years, or the offence which was being tried is a bailable offence, and in such case, if the accused is already on bail and he is applying for a bail to appeal before an appellate authority, in such cases, he shall be released on bail by the convicting court. Section 395 again talks about bail in cases of reference. So while referring a matter when a reference matter is being taken up, in such cases also bail can be granted. Also in revision cases under Section 397 to 402, bail can be granted. Another provision is 437A, which says that bail to appear before the next appellate court. So it is talking about that bail shall be granted to appear before the next appellate court against the decision of the appeal for a max period of 6 months after executing bail bond with surety. So here also another bail can be granted. Now we'll talk about the default bail other. We had already discussed one default bail. Now we are discussing section 436A, which is another default bail, that is maximum period of detention for UTP. So during investigation, inquiry, or trial, that means at any stage, taking into consideration all the stages of the trial, that is inquiry, investigation, and everything, a person who has undergone detention for half of the maximum period of imprisonment prescribed. So that means if the offence alleged is punishable with imprisonment for 3 years, and the accused has already stayed inside the detention or custody for 1.5 years, and investigation, inquiry, trial, all the stages put together are not complete, then he shall be released on bail on personal bond with or without surety. This is also a mandatory provision. It's a default bail. When if half the maximum period of imprisonment prescribed has elapsed and the accused is still in custody, then he shall be released. Exception to this rule is that in offences which are punishable with death, then half how to die in a how to half that. So there is no provision to do that. So in of course that way, uh, this is an exception. The period can be further extended or bail can be still insisted instead of personal bond if after hearing the PP or the public prosecutor and recording reasons there arises such opinion by the. So this period of half of the maximum period of imprisonment can also be increased further, but in no case such detention shall exceed the maximum period of imprisonment prescribed for the offence. So when someone asks you what is the maximum period one UTP can stay inside the jail for uh, all the stages of investigation, inquiry, or trial put together, that would be the maximum period of imprisonment prescribed for the offence. And of course, any delay caused due to the accused, that is the fault of the accused, or he did not insist upon police report paper, that's the reason it was delayed, or he did not start his evidence, that's the reason it was delayed, or he did not come for charge, or he did not appear. If any such delay is made because of the fault of the accused, then such period shall be excluded while computing the period of detention. Now comes the most talked or most confusing, rather says, I would not say it is such confusing, but then widely it is being treated as a confusing provision, that is section 167(2), that is default bail or statutory bail as largely put. It is talking about the fact that if the maximum period of detention of the accused is before the charge sheet is actually submitted, uh, and the charge sheet is not filed within the prescribed time frame, then a legal fiction is created in favor of the accused, which entitles him to be released on bail. So the maximum period of detention of the accused before the charge sheet is filed is 90 days, which is increased to 120 days in Odisha as per Odisha Act of 91, Odisha Act of 1997, and often for offences which are punishable with death, life or 10 years, and the maximum period of detention is 60 years for any other offence. So on expiry of the said period, he is and if he is prepared and does furnish bail, then he shall be released on bail. All these bails are to be deemed to be treated as if he has been released under chapter 33, that is the normal chapter of bail. So all the provisions of that chapter shall by and large also be applicable to section 167 clause 2, because there is a deemed clause here. So as we discussed, if the charge sheet is not filed within the time frame, then a legal fiction is created in favor of the accused, entitling him to be released on. Now we'll discuss all the, this is the bare provision, but there are very many confusing ingredients of this section, and we'll discuss them through case laws. One important uh, question always comes up while discussing section 167(2), whether it is actually a statutory right or a fundamental right. Because if it is a statutory right, then it can be suspended during emergency, or it can be suspended during the ongoing COVID pandemic that is right now going on. Because for that, certain rights can be curtailed, but the fundamental right cannot be curtailed during any emergency situation. That is the reason it is very important to know whether such right is a fundamental right or a statutory right. But in Bikramjit Singh's state of Punjab, the Apex Court has made it clear that it is a fundamental right. And in S. Kasi versus State, it was also reiterated that it's a fundamental right under Article 21 and it cannot be suspended even during a pandemic. It's a very recent case that is of the 2020. So in such case also it was held that it's a fundamental right. Another important question that comes up is that what dates are included and what dates are excluded while computing the set period of 90 days, 60 days, or 120 days as the case may be. Because it is very confusing that the accused is remanded on a certain date, whether that date is included or whether that be excluded, whether the date on which the charge sheet is being submitted that is to be included or excluded, whether there are any the last date of the uh, statutory period ending is a holiday, whether in what will happen in such cases, there are many such legal problems arise. In M. Ravindran versus Intelligence Officer DRI, it was held that this is the latest position. There has been always conflicting views that whether which dates are to be included, which are dates are going to be excluded. But this is the latest position that the date of remand to judicial custody, that is the date when the accused was remanded to judicial custody, is to be excluded, and the date of filing of charge sheet, the date of filing of charge sheet, that is to be included. I missed by mistake. I have written excluded. I'm really sorry. That must be included. The date of filing of charge sheet uh, must be included. So this legal problem that we always face, that what dates are to be included and what dates are to be excluded. This is very clear because the filing of charge sheet, that date and that is to be excluded, and the date of remand to judicial custody is to be excluded. I've written excluded in both cases, and I will correct them and then probably give it to you. So you please note that the date of remand to judicial custody, that is to be excluded, and the date of filing of charge sheet, date of filing of charge sheet, that is to be included. Now comes R.K. Paul versus State of Assam, which is another landmark case, which actually says that whether on oral application of the accused a default bail can be granted. This 2017 judgment, the court observed that the court should not insist on hair-splitting technicalities, and even on oral application, a default bail application or a statutory bail application can be entertained. Another important question that comes up is that whether cash security in default bail can be insisted upon. The Supreme Court has made it clear in this case, Saravanan versus State, and many other cases, excuse me, that no cash security can be insisted in default bail, as it would defeat the very purpose of enlarging the accused, because the charge sheet could not be submitted within due time. Another important question that always comes up is whether this bail can be cancelled, because it is not an ordinary bail, this is a statutory bail, and this is a compulsive or default bail. So whether it can be cancelled, it has been given in V. Balasubramaniam versus Intelligence Officer that such bail can be cancelled under section 439(2), as he is deemed to be, as the accused here is deemed to be released under chapter 36. We had already discussed that it is deemed to be released under chapter 33. So that's why in V. Balasubramaniam intelligence officer, the bail given can be cancelled as he is deemed to be released under in Ramakantur versus State of Odisha, it is saying that NDPS Act Section 37 does not override Section 167. Another important case law is that SK Raju versus State of Odisha 2020, which says that whether this is one condition, whether if the last day of the statutory period, if that is falling on a holiday, then what will be done in such cases? This case actually makes it clear that even though the last date, actually Section 10 of General Process Act, it says that if the last date of any statutory period is falling on a holiday, then another extra day can be given for compliance of the same. By and large, it says that you can please go through Section 9 and 10 of General Process Act, which will by and large say this. So if uh, that falls on a holiday, then whether the IO can avail another extra day, that is on 61st day or 91st day or 121st day, as the case may be, whether he can file the charge sheet and it will still be okay, and the accused can still be detained in custody for the one extra day. This case, which is a landmark case, says that no, it cannot be done. And even if the last day of the contemplated statutory period falls on a holiday, the IO is bound to submit the charge sheet by that day, even if it is a holiday, to disentitle the accused, disentangle, not disentitle, disentitle the accused to claim default bail. This is the autocorrect that has done, ignore the mistake again, disentitle the accused to claim default bail. So even if it is a holiday, even if it is Sunday or Holi or Raja festival for that matter, IO is still bound to submit the charge sheet because the criminal courts are presumed to be open 365 days, 24/7. So that's the reason the IO has to submit the charge sheet even if it is a holiday. Another important case is that Lambodar Bagh versus State of Odisha, which says that the notice to the accused while considering extension of time beyond the prescribed period of 180 days under Section 36A of NDPS Act. That is a mandatory notice that has to be given to the accused because the prescribed period here is being increased. That's why notice is that's not such so important. So you may skip this. Another important case we had already discussed the M. Ravindra case. M. Ravindra versus Intelligence Officer DRI 2021 case. In that case, another important position was made clear that what happens in a case if the accused is actually offered bail and he has not furnished the bail, and if he has not furnished the bail as directed, and the charge sheet is actually submitted in the interim, then what is the position here? Because in this case the accused has been offered the right of statutory bail, he has not complied with the conditions, that's why he is not released, and in between the charge sheet is actually being submitted by the IO, then what will happen in such a case? Because there will be a conundrum because the charge sheet has come, but the accused has not yet been released, but you have offered the accused a bail. In such case, in that this M. Ravindran case, it was held that another legal fiction is created. The accused is deemed to have forfeited the right, and his continued detention beyond that period can also be justified, and it will be presumed as if he has forfeited the right to be released on bail, and the charge sheet can be still be accepted. The SK Raju versus State of Odisha, another position was made clear of. This is 2020 case again, that bar charge sheet if in compliance to 173(2) or this I'll ask again that whether a preliminary charge sheet can be submitted. Preliminary charge sheet can be submitted, and it will be good, or it will be good enough to make sure that the statutory period will not be counted further, and the accused will be still inside the custody because the IO has supplied the preliminary charge sheet. Though of course in this case it was given that uh, preliminary charge sheet, there is no such word called preliminary charge sheet, and if there has been a charge sheet which is filed in compliance to 173.2, even though it is not complete, and even though there are missing elements from the charge sheet, if it is in compliance to 173.2, then then the such charge sheet will be allowed, and that will disentitle the accused from being released on bail. But just because of just because it says that, it doesn't mean that the IO can file anything and still get away with the provision, and it has to be in basic compliance of 173.2. That means a charge sheet which is to be filed by the accused by the IO, pardon me, IO, which will be enough for the magistrate to take cognizance on the basis thereof. Then in such case, such charge sheet can be accepted, and that will disentitle the accused from being released. Another important case is Gautam Naval Lakha versus NIA 2021 case. Again, here it is saying that what if the accused is in jail for some days, I mean he's in custody for some days, and then he's released on bail, and then he comes back to jail because the higher court again changed it, and then the higher court to that actually changed the position again, and he's again on bail. What happens in such cases? It says that the broken periods of custody are to be computed together while computing the statutory period, and all the period that he has been inside jail will be taken into consideration, and such default period will be computed. The cancellation of bail provision 437.5 and 439.2, we have already discussed how a bail can be cancelled in what cases. Obviously, if the bail has been enlarged and he fails to comply, or the High Court or the Session Court is of the view that it wants to modify or cancel a bail, then it can do so. Then bonds and miscellaneous provision. Section 440 is fairly important. That is, amount of bond that is to be asked by the court cannot be excessive and should be according to the circumstances. We'll discuss certain important case laws. That is, N. Sushikala versus Enforcement Officer, in which it was held that a bail bond of 3 crores is actually excessive, and a bail required uh, by police or magistrate can be reduced by High Court or Sessions Court, that we already discussed. 439.2, it can be done so. There are other provisions which deal with various provisions of bond. That is Section 441, which says that while being released on bail, a bond of certain amount shall be executed, and it is to contain conditions. Section 441A, which says that a declaration is to be made by the surety who is actually taking the person on bail as to the number of persons to whom he has stood surety. So he'll disclose that these are the persons to whom he has stood surety for. Section 442 is speaking about that after the bond is executed, then only the person will be discharged from custody. Section 443 says that bail, if accepted on insufficient sureties, then warrant can be issued and sufficient sureties can be asked for again. Section 444 says that discharge of sureties on application. That means if sureties which have stood for the person who has been released on bail, they can apply that no, we don't want to stay as sureties anymore, and they can be discharged, and further fresh sureties can be replaced, and if not, then his bail will be cancelled. Section 445 can demand, can entitle that if the applicant is seeking to deposit instead of the bond or the recognizance, then that is to be allowed. That is, cash as such can also be deposited if the court is of the view. Section 446 says that how the bond is forfeited. It talks about that in detail. 447 talks about the procedure in case of insolvency or death of surety, or when the bond is forfeited. So that means if the surety dies, or there is an insolvency of the surety, or when the bond is forfeited, then a fresh surety is to be called for, and if there cannot be a fresh surety, then the bond shall be forfeited and the bail can be cancelled. 448 speaks about bond required from minor. 449 speaks about the appeal from 446 order to sessions judge against the order of magistrate and appellate court against the order of sessions judge. It's not of that much of importance. It doesn't generally, you should know, but then it's not that important. 450 amount due on bond, then High Court of Sessions Court can direct levying of fine. These are the miscellaneous case. Now, further reading, as I mentioned, that GCPR case, this is one case that we have to must go through because this is actually like laying down the principle or the uh, jurisprudence of anticipatory bail in what cases, how anticipatory bail is to be dealt with. That has been very beautifully laid down by the Honorable Court. In Guddi Kanti Narsimullah versus PP Andhra Pradesh, it was said that how bail is actually safeguarding Article 21 and the entire jurisprudence of Article 21 vice versa bail and how the bail is actually protecting the personal liberty of the people. That provision and how the courts are to be dealing with bail that has been very well beautifully narrated. So please go through this. Papu Yadav versus CBI is another case in which uh, the court. These are the cases I'll discuss. Three court cases in which there have been various contradicting views taken by the court. That is, in Papu Yadav versus CBI case, that the allegation was for a conspiracy to murder, and in such case, 10 bail applications were rejected. And when the bail was moved to the Supreme Court, it was rejected again. Even then, even when actually all the evidences, all the witnesses, vital witnesses were examined already, still then the bail was rejected on the ground that the allegation is very severe and that is the reason the Supreme Court rejected. So generally the courts are of the view that when the possibility of tampering the evidence is over, when all the witnesses and the evidences of the prosecution are examined at length, such cases generally bail is granted, but this was an exception by an honorable Supreme Court had rejected this. In contradiction to that, Sanjay Chandra versus CBI 2012, which is 2G case. It's a large-scale corruption case in which Delhi High Court had rejected, even though all the applications were completed, Delhi High Court had rejected the bail, but the Supreme Court actually went ahead and allowed and said that the Article 21 is above all and should even prevail over the sentiment of the community at large. And just because the offense actually is being condemned in the society, that is the reason. For that reason, it cannot be denied. The bail cannot be granted. The bail cannot be denied. It actually reaffirmed the Justice Krishna Iyer's view that bail is the rule and jail is the exception in this case. Please go through this judgment as well. Another judgment is that V. Goda versus State of Andhra Pradesh, in which this is uh, of our beloved Justice, Honorable Justice Deepak Mishra, that severity of offences are to be viewed as well while deciding a bail application. That was reiterated. P. Chidambaram versus a Director of Enforcement in this 2019 case, when the eminent lawyer P. Chidambaram approached the court for a bail, it was held that in economic offences, it might not be the right thing to grant bail. Another important case you must read in case you want to clarify the bail jurisprudence in your mind, that is Social Action Forum for Manavadhikar versus Union of India. Jurisprudence of arrest, vice versa, bail, all this is given. So please go through this judgment. By and large, we have actually discussed all the provisions of bail. So if anyone has any questions, anyone, was my voice not clear? Could not be heard? I am so sorry. I have not seen the message. Was it the case? Was it the case that nobody could hear it? Please respond.
Excuse me, sir.
Yes. Could anyone hear it? I mean, completely, or was I not audible at all? Okay, okay, okay. Please excuse that because I've come to my hometown and there is poor network connection here. As you can see, I'm sitting in the balcony, so that is another ingredient which contributed to this inaudibility or lack of clarity in the lecture. Uh, that will be addressed from the next class onwards. So if anyone has any doubt, please
Excuse me,
let me
sir.
know. We'll try to discuss them, or it should be a fruitful discussion. I have only 10 minutes with me. I have some other commitments, so we can
Sir,
discuss. If you want to, yes, please ask.
sir, even if the default bill is statutory provision, does the court have any sort of discretion in giving the default bill?
I did not get your question. I couldn't hear it properly.
So even if the default bill is statutory and the court shall give it according to the provisions, does the court have any discretion in giving the default bill?
That can be the questions can be interpreted in two ways. Are you asking that whether any conditions can be put, or whether the court is bound to releasing bail, then releasing bail?
Yes, yes, sir.
What are you asking?
The latter one is the court bound.
Yes, of course. If it is a statutory bail, if the period has actually elapsed, then the court is bound to release the accused person on bail. There is no other way to interpret it.
Sir, in practical scenario, does this happen?
In practical scenario, I would not say anything uh, which would be unparliamentary, as they put it, or uncourt worthy. So I can't really say that. But by and large, it is made sure that in practical parlance, in all cases when a default bail application comes up, the magistrate has just one job in hand, that is to compute the period. That is, he'll exclude the day the accused was remanded to judicial custody, and he will include the date of the filing of charge sheet, and he'll compute the period, whether 60 days, 90 days, or 120 days that are over, and he'll also make sure that all these nonsense um, uh, provisions that are taken by IO, that is a holiday, so we could not submit it. All these are to be excluded. So the court will decide all of that, and it will just compute the period. And if the period is complete, then he shall. It's a mandatory. It's a non-obstante thing. The court cannot escape it.
Thank you, thank you.
Sir,
Yes.
sir, my question is regular bill or required after anticipatory bill?
As we discussed, regular bail is not required. We discussed. I'll go to the judgment again. I'm bad with judgments. I'll just reiterate the judgment again. Wait. Anticipatory bail, in which case we held. Yes, there is no time limit. There is no time limit here. It was yes, right, right. Yes, Satlingappa Maitre versus State of Maharashtra, it was held that the anticipatory bail can be granted for an unlimited period until the trial is completed. And though in Adri Dharandas, State of West Bengal, it was given that the accused is required to surrender and obtain a regular bail, uh, still the S. Satlingappa Maitre versus State of Maharashtra and the Gurbaz Singh Sivia versus State of Punjab being a 5-judge judgment actually overrides that, and thus the bail granted under 438 is believed to have been granted for an unlimited period of time until the trial is actually over. Okay.
Thank you, sir.
Thank you. Any other
Sir,
doubts?
sir, I have a doubt. Sir, you have told that under section 438, both Sessions Court and High Court have concurrent jurisdiction, and
Right.
but in general, Odisha High Court has ruled that first Sessions Court should be approached. Sir, can you name the decision, sir, for us?
I'm sorry. As I said, I'm very bad with judgments, but I'll supply the case. This is a recent case which Honorable Justice Sanjeev Panigrahi has actually held in Kendrapada case, I believe. I don't know the name. I will supply the case in the group.
Thank you. Thank you, sir.
Okay.
Sir.
Yes.
सर गोटे केस रेजिस्टर है धर 307 कि एनी सेशंस ऑफेंस से अक्यूज फॉरवर्ड है अक्यूज ओमेन अच्छी सिक अच्छी कौन वेदर मजिस्ट्रेट बेल दे पारे
मजिस्ट्रेट दे पारो नहीं
ट्राइबल बाय सेशंस ट्राइबल बाय सेशंस किंतु ओमेन है किंदा सिक अच्छी
नहीं से केस दे
पारे सर सेकंड पेज रे सर जो से सेकंड पेज टर थिला से जो ऑप्शन जोठी माइनर 16 ईयर से सर आपन को प्रेजेंटेशन नो सेकंड पेज
प्रेजेंटेशन नो सेकंड पेज रे देछि कि offenses alleged are punishable with death or imprisonment for life, previously convicted in a cognizable offense punishable with death or life or imprisonment for 7 years or imprisonment for more. But जोडा आपण एटा कहउछंती जो
आया
जो नॉन बिलेबल ऑफेंस जेतेले हम कहू इन प्रैक्टिकल आपण जदी एक्चुअली इंटरप्रेट करिया जिबा इट्स ट्रू दैट सेशंस कोर्ट रे भी देई हबा कथा, बट देन in practical parlance दिया जाएनी. The reason being कि exclusively tribal by court of sessions, so the magistrate generally does not interfere and it leads to the sessions court. जेमति कि आपण देखिबे कि 438 रे पूछि कि 438 पूछि कि जे हाई कोर्ट ऑफ सेशंस कोर्ट दीटा कोर्ट करबे, बट काहे कि हाई कोर्ट सब बळे कराउछि सेशंस कोर्ट दे परंता जनरली मु तो देखिनी केबे सेशंस कोर्ट नॉर्मली दियंती जहां भी इंस्टेल्ड क्लियर हो व्हाटएवर कैन बी द रीजन, बट दियंती तणो सेम
छोटा दियंती सर मजिस्ट्रेट ट्राइबल द
फास्ट एतरे दियंती नाही.
आया सर आ गोटे सर अच्छा धर गोटे केसटा हमर 307 रे रजिस्टर हेछि 307 रे रजिस्टर अछि अक्यूज भितर अछंती सर ऑन कस्टडी आगे से माने 439 रे हाई कोर्ट को जाइछंती बेल पई बेल अलाउ हो जाइछि सर हाई कोर्ट बेल अलाउ कर देई हंदी सर जो दिन से माने दउछंती धर से ता भीतर पुलिस चार्जशीट दउछि 302 रे किंतु हाई कोर्ट रो बेलटा 307 अनुसार अछि ताल कोन करा हो सर
तो आपण माने कहउछंती जेतु 307 रे थिला एबे 300
आज्ञा 307 थिला मझी रे मरि जाइछि इंजर्ड हेकी थिला सर ता भीतर मरि जाइछि किंतु से माने 439 रे पळै हंदी हाई कोर्ट देई दैछंती ता भीतर से जोन सबमिट करछंती कोर्ट रे किंतु ता भीतर पुलिस आनी कि वर्तमान चार्जशीट दउछि 302 रे
तो मैजिस्ट्रेट कोन करियो
आज्ञा
according to me if it has been given by the high court the magistrate will not interfere it unless because bintu sethi keeping kora duty ashi that shall be informed to the court and they can probably do something about it, but it is generally magistrate kichu kar kariye.
Sir, thank you.
Okay, anyone else has any doubt or will wind up the lecture?
Also,
yes
sir, in what cases anticipatory bail cannot be given?
In what cases anticipatory bail cannot be given?
Yes, sir.
Generally there are many guidelines of the Supreme Court that in economic offenses anticipatory bail are not given. In cases which are uh, uh, very severe, such as we had discussed some of such cases. That is, one is for sure, it does not apply to SCST Act. So in SCST Act cases also, anticipatory bail cannot be given. So there are many provisions. I mean, very many guidelines given by the Supreme Court. On the basis of that, we can say that in these cases, anticipatory bail cannot be given. But if CRPC does not actually prohibit anything except that for that of a bailable offense, of course. In bailable offense, according to CRPC, uh, an anticipatory bail cannot be given, but in other non-bailable offences, uh, it should be given if there is another other special law, as also mentioned in TADA cases, in SCST cases, those cases which are very serious in nature. As a practical rule, it is being followed that anticipatory bail is not being given.
Thank you, sir.
Any other case, any other thing, or we'll end it here? Okay. Thank you. And if anyone has any further doubt, they can post the same in the group, and I'll try to take them up again. I hope it was a productive lecture or a productive session to you, as it is to me always. It is always pleasure interacting with you and learning so much from you. It's a forever learning curve, and I insist that whatever stage you're in, please never give up this idea of or quest of knowledge. And all the best. Thank you. Good night.